Just before the holidays, we covered the manslaughter trial of Kim Potter, the former police officer who killed Daunte Wright during a traffic stop back in April of 2020, right up to the moment the jury found her guilty. We're still a few weeks away from sentencing, but tonight we're hearing from one of the jurors who decided Potter's guilt. Out of concern for his safety, the juror didn't reveal his name or talk on camera, but there are pages of records from his conversation with KARE, a TV station in Minneapolis, where he recalls the deliberation process and the big turning point for the jury. Still with me are my panel of legal experts, BNC's legal contributor Paul Henderson and criminal defense attorney Bernarda Villalona. All right, let me just say that if most juries are as sharp as this anonymous juror and his colleagues, I'd have a lot more trust in our jury system. It's incredibly rare to get a glimpse into the minds of jurors in a high-profile trial because most of them want to put the whole ordeal behind them. But this juror gave us details about what went on inside that deliberation room. Were any of you surprised to know that after closing arguments, the majority vote was to convict Potter on both counts? Bernarda.
I wasn't surprised at all because I think what sealed the deal was Kim Potter testifying. It was a complete game changer when she testified because she didn't come off as credible. She came down with using crocodile tears to try to move the jury, and it completely backfired on her. So I think if hadn't she testified, then the jury wouldn't have come back so quickly with a guilty conviction, but she did it to herself.
Paul.
Well, I had some real concerns, and anytime you put the defendant on the stand and, she's using those tears and not tears, but crying and apologizing and making it clear that this was just a mistake. I mean, my real concern throughout the entirety of the case was having the jury truly understand the distinction between an accident and a mistake. And to me, the fact that they were able to get to a mistake and understand that the difference is legally and that you can have an accident, but that's different from making a mistake. And when you make a mistake, that you can be culpable and liable. And that's what I was really concerned about. I really wanted the district attorney and the prosecution to focus on that issue a little bit more, because oftentimes it's a black hole that a jury can fall into and not understanding the difference and being distracted by a defendant that testifies well, or a defendant that cries, or a defendant that apologizes. And in cases like this, where you have a negligent homicide, or let's say, for example, you have someone that's in a DUI and accidentally kills someone, or someone that's speeding that accidentally kills something, which is the type of case, those cases hang on the jury understanding that distinction and difference between an accident and a mistake. And to me, that's what I was focused on for this jury and hearing their explanation for that.
Now, the juror also talked about how they went through the process of getting to a verdict. They had big group discussions and even broke out in smaller groups to talk through the meaning of legal terms like conscious or intentional act. The juror made a point to say that the facts in the case weren't in dispute. The debate was over the interpretations of the jury instructions and the law. What does that say about how we as lawyers need to approach juries in trial, Bernarda?
Well, it's huge. When you're talking about closing arguments, that's your purpose right there. Your entire purpose is to break it down, the jury instructions, into simple terms, especially when you're talking about a case that falls on the law itself. Not about what happened, but how do you apply what happened to the law as it's given to you? Because you have to remember, they also had those jury instructions with them while they were deliberating. I think it was like 14 pages of jury instructions that held the fate of Kim Potter in her hands. So in their hands. So in terms of that, it's more important as a trial attorney is to know how to argue your case and just break it down into simple terms. That's the thing. Instead of just dragging everything out with just legal terms, tell them what to do and how to do it and how to approach it. And then that way it'll be easier for someone to actually comprehend what's being told to them. And I think that the prosecution did that in one sense when they laid out that mistake. You will not find the word mistake in those 14 pages of jury instructions. That is not a defense in this case.
Well, besides the difficulty of having to understand the law, the jury also had a hard time dealing with the consequences Potter would have to face if they found her guilty. Paul, this is something I think all juries think about, even though they aren't supposed to, especially in cases where the defendant is sympathetic.
100%. And you know as well as I do that these are some of the things that jurors will tell you after you've completed a trial. Every trial I've ever had, I've rushed afterwards to try and talk to the jurors to understand here. And this is one of the things that they bring up regularly, that they were really concerned about if they find that person guilty, what they're likely to face. Even though they're not supposed to talk about it, they're not allowed to talk about it. Sometimes they talk about it and they absolutely consider it. And that's the job of prosecution, to explain to the jury that that's for someone else. That's for another type of analysis that they are not called upon to do, to try and remove that. And it's the prosecution's job to articulate a pathway for them to evaluate the evidence and to find the facts and to find guilt or innocence for the facts, and not contemplate sentencing. It's almost like an artificial approach intellectually that they have to take, but it's the prosecution's role to explain that to them so that they're not distracted from doing their job, which is to evaluate the evidence as presented in the trial and then to come to a conclusion. But that never stops looming over the background of every prosecution and every trial that you're trying to put in, because you know a jury, just from their natural reaction, wants to evaluate, is this going to be something that someone is going to be held liable for, and what does that translate to in terms of years or custody?
Well, the juror also talked about that pivotal moment when Kim Potter took the stand. The juror said he was surprised to find that people questioned Potter's tears, whether they were genuine or not, but because the jury believed that she was really sorry. The juror also said he thought it was ludicrous that some people assumed the jury believed Potter to be a racist, that racism never came up during deliberations. Is that surprising to you, Bernarda?
It's not surprising to me. You got to think that the jury was compiled of 11 Caucasians and one African-American person on the jury. So I'm not surprised. The thing is, who thinks about race? Those that are affected by race, and that would be us. So of course, that conversation is not really going to take place if we're not inside of that jury room. In terms of whether race came up, of course, with the prosecution strategy, what they took was to make this case not about race. And people were talking about why isn't the prosecutor addressing race? They knew who their audience was, and that audience was those 11 white jurors and the one African-American person that wouldn't accept a type of argument of using that of race. Also, in terms of them believing Kim Potter, in terms of her tears, whether they're genuine or not, I think, and as we saw it in the video, was she upset? Yeah, she was upset that she did something wrong and that she was caught doing something wrong. And even through her own words, I'm going to jail. So yes, there's a huge difference about being upset because you feel for the life that you've taken. And there's a difference in terms of being upset because you're going down for it. Because I'll tell you one thing that did upset me. Did y'all see her mugshot? Was she smiling? Is that someone who was sad?
Mm-hmm.
No.
Paul, I don't know if I remember this correctly, but I think you were the one that said that you wished that the prosecution had brought up racism in some way.
I wanted to hear a conversation, and the real arena for that is the accountability that takes place beyond the criminal accountability. So in the administrative accountability, where we have policies that address race disparities for how encounters like this subjectively get elevated rather than using tools of de-escalation. That's the issue, and that's what's behind this case. And yes, when we have a criminal trial, it's accountability for that singular victim and that singular incident that's case specific. But the bigger issue and the conversation that we need to have addresses race disparities and the lethal encounters from communities of color, Black and brown communities, specifically unarmed Black men. And that's what I was saying was so important. And there's not a real way to bring that up through the trial specifically, but it's a real issue that is absolutely reflected in the behavior from this officer and in law enforcement in general, that we have to talk about the choices that officers make, the real or perceived fear that they have encountering Black and brown communities, and the subjective use of lethal force as encounters are escalated into encounters that end very badly. That's the point that I was making, and I still think it's a relevant point that we have to be addressing in this country based on not just this case, but other cases as well, but absolutely inclusive of Kim Potter and her subjective decisions not to be checking her gun, her subjective decision to feel fear, her subjective decision not to check her taser to see which gun she was shooting, and then obvious accountability that we had in the trial.
Well, running out of time, we could talk about this all night, but the juror did indicate that the pivotal moment for them during deliberations was the comparison of the gun to the taser. Paul Henderson, Bernarda Villalona, thank you so very much for your time tonight and insight.